Okay.
button. It says recording, and we should get a thing that says recording. Yes. Okay.
I'll admit
right.
everyone in.
Okay.
There you go, Yohei.
All right. Good afternoon, everyone. Welcome to the session about O1s and H1Bs, and this is sponsored by the Office of International Education. My name is James Dorsett, and I am the director here, and I'm joined by my colleague, the Associate Director, Brandy Shackelford. And then we are also joined by three faculty members. I will quickly let them introduce themselves. Hey Lynn, Eduardo, and then Yohei. Hey Lynn.
Hi everyone, nice meeting you guys. I'm currently teaching graphic design and GDMA course at MICA. I'll pass it to Eduardo.
Hello everyone, my name is Eduardo Corral, but I go by the pseudonym Tlaloc. I teach in the first year experience department. I'm the coordinator of first year fellows department, and I also teach in illustration. So nice to meet you all, and Yohei.
Hi everyone, my name is Yohei Horishita. I'm a full-time faculty in the illustration department. Yeah, that's it.
All right, thanks, all three of you. I will now introduce our attorney from New York, who is an immigration attorney and has a wonderful practice there, and she is going to give us the ins and outs of the H's and the O's, and then after that we will go back to our faculty panelists, and they will talk about their O1 experience, and then we'll open it up for questions. So I will turn it over to Electra.
Thank you, James, for such a warm introduction. I'm very excited to be here on this panel with all the faculty, and I'm more excited to actually be the starting point of your O1 journey or your H1B journey. It is a very exciting and scary time because right now it's high season for all the law firms. So just to reintroduce myself, my name is Electra Yao, but I'm known as the artist visa lawyer. I have a lot of content on social media, on TikTok, Instagram, Facebook. I have a cumulative following of 60K. So please be sure to follow me after this session, and feel free to email me so I can send you guys my O1 ebook where I give you like my little tips on how to strengthen and architect the petition and the letters of recommendation. Now, the dichotomy or the questions surrounding H1Bs and O1s is something that I encounter all the time. And I always invite my clients or prospective clients to try to think about this conceptually and long-term. So let's start by having this conceptual discussion by discussing the differences between H1Bs and O1s. And I think everyone has probably a baseline knowledge of H1B being something that is more of a traditional type of employment, and O1 being, a lot of people make this mistake, freelance or gig type based employment, which is not necessarily the case. So the major difference of H1Bs and O1s is employment. So for O1s, you can have a very broad career where you can accept different types of employment. And for H1Bs, it's pretty much traditional unless you're filing a concurrent H1B. So you're filing two H1Bs simultaneously. A big misconception about H1Bs is that creatives and entertainers and models cannot file them. They can, and they do. It's just much more restrictive in terms of employment compared to the O1. So what is employment under the O1 sphere? So employment under the O1 sphere is very fun and very different compared to the H1B because we can do a lot of different things. So for the O1, you can have traditional employment, so 9 to 5, W2. This is a big misconception. A lot of the times people think that you cannot have traditional employment. You can have project-based employment, which is basically a company is like, hey, Electra, can you do this project for me for 3 months? You can work for a private individual. So let's say, for example, you're a graphic designer and your friend is an influencer. It's like, hey, Electra, can you draft or create a graphic for me to use this week on my social media? And most importantly, with O1s, you can do international work on US soil. So if you are, for example, from South Korea, and a South Korean production company wants to hire you to work in the States, that absolutely counts as employment. So those are like 3 or 4 different types of employments that are very unique to the O1, whereas H-1B, we have to be in a specialty occupation for an employer that's going to petition for you. Now, O1s, you can have an employer-based petition, so you can have a company like Netflix petition for you, or you can be petitioned by an agent. This is not the case for the H-1B. For the H-1B, you've got to be filed by a traditional petitioner, which is an employer. For O1s, you can be filed by with a petitioner, which can be an employer, or what is also known as an agent-based petition. So an agent is anybody that's a US citizen, green card holder, or any US-based company. So right off the bat, I've just illustrated the major differences, which are how the case can be filed, so employer versus agent, and the types of employment that can be undertaken during both visa types. Another major difference is, for example, the prevailing wage. So for H-1Bs, you have to make a prevailing wage. This is a wage that has been set by the government, and you have to make this amount of money. The reason for this, or the congressional intent behind this, is because in the 70s and 80s, US-based employers were taking advantage of foreign nationals. What they were doing is they were paying the foreign nationals a lower wage compared to their US counterparts. And Congress's way of remedying this is to create what's known as the prevailing wage, so a minimum amount of salary that the foreign national needs to make in the position he or she is applying for or has been hired for. The same is not true for the O1. There's no prevailing wage requirement. You're not required to make 50 grand a year or 100 grand a year or 12 grand a year. There's no prevailing wage requirement. However, a really good rule of thumb is to make a livable wage in your state. And I have seen, for example, RFEs that have invoked the federal labor standards where they're saying, or the USCIS is saying, that the foreign national is not making the federal minimum wage requirement. So that's something that you want to be aware of. So there's no formal documentation in the federal regulations or in the law that states that you need to make a minimum salary. But of course, a good rule of thumb is that you should make a minimum wage. Another major difference between the H-1B and the O-1 is who can pay for the case. So for the H-1B, the employer, the petitioner, has to pay for all of the legal fees and the filing fees. It is contrary to the law for an attorney to accept any legal fees or filing fees from the beneficiary, the foreign national. Please be mindful and please be aware that if you have an employer who's like, okay, I'm going to pay for the legal fees and the filing fees, but I'm going to scale that or take that away from your salary, that is not permissible by law. You should be aware that they are potentially taking advantage of you. And if the attorney knows, the attorney cannot accept that sort of fee agreement. You as a foreign national cannot pay any of the legal fees or filing fees. For the O1, anybody can pay. Your grandma can pay, your boyfriend can pay, anybody can pay for the filing fees and the legal fees. So you're not tied to a traditional employer or traditional petitioner, just like your H-1B counterparts are. Another major difference is the amount of time you can be on each visa. So for the H-1B, it is renewable. Well, first of all, the H-1B lasts for 3 years. And it's renewable for an additional 3 years, or you can extend it for an additional 3 years for a total of 6 years. In order to extend it again, you need to have a PERM application filed on your behalf. A PERM application is basically the green card version of the H-1B. The same is not true for the O1. You can be on the O1 indefinitely. I have clients who have been on the O1 for 20 plus years, and that's perfectly fine. You can absolutely do that. It is one of the major differences between the H-1B and the O1. At one point, the employer needs a petition for you. Over here in the O1 world, nobody ever needs to petition for you for the green card. Of course, this also leads to, does the O1 lead to a green card, or does the H-1B lead to a green card? Now, the H-1B, you can have a PERM application filed on your behalf. So it doesn't necessarily lead you to a green card, but the natural occurrence or the natural step, should you be a good fit for the company, is for the company to file the PERM application. For the O1, it's kind of similar. There's no path to a green card. You can have dual intent, so basically the intent to stay here temporarily and the intent to stay here permanently. But just because you've been on 20 O1s, that does not mean that you automatically qualify for the EB1A self-petition green card or the EB2 NIW self-petition green card. This is something to be aware of when you are undertaking your O1 career and your O1 time, to be very strategic about the projects that you're taking, the press that you're getting, because you want to utilize this O1 time to really make sure that you're hitting the different federal regulations or the different requirements for the EB1A. Just a short parentheses here, the EB1A or the green card, the artist green card may not be a good fit for everybody. Of course, once you become a permanent resident, there are fiscal considerations that need to be made in terms of understanding if your country is part of double taxation treaties, things that obviously you need to consult with a tax attorney. Unless you're going to a tax attorney and an immigration attorney, that is one person. These are things that I think are very, very important to consider depending on what your country of origin is. Now, for the O1 and the H1B, a lot of the times I have clients who are from South America and they think that maybe their dual citizenship with a European country is going to be something that helps them qualify more. That is not the case. You can be South Korean, you can be Japanese, you can be Guatemalan. The law does not make any differences in your nationality for O1 and EB1A purposes. For the H1B, once you file a perm application or a green card application, of course, certain nationals are on a waiting list. And this waiting list is published every month by the Visa Bulletin, where you would see if your priority date is current, meaning you can adjust your status and get your green card here in the US. Does anyone have any questions so far? That's a lot of information, and I just want to make sure that I'm opening up the floor to anybody that might have specific questions about either H1B or O1.
Electra, actually, I have a question regarding what you just mentioned, which is like depending on the country, there's a page where I can see like where I'm from Mexico, for example, like where my country is like prioritized. Like, can you, I guess, like share this with us in the
I'd have to like go on the internet and like Google Visa Bulletin, but what I can do in the chat later on is I can, like, when someone else is speaking, I'll just put the link in the chat.
Thank you.
But yeah, another major difference, and I think it's something that is to creatives and artists' favor. Oh, can you talk
about the H1B cap and cap gap?
Okay, yeah, sure. So the cap gap is very important. So for example, for the H1B, you can only start working October 1st, which is the beginning of the fiscal year here in America. In terms of business and economics, it's our last quarter, but for immigration purposes, it's the beginning of the fiscal year. So what happens if you like graduate in May, you got accepted into the lottery, you filed the petition, you got approved, and you know your EAD card is about to expire? No problem. What the government will do, or what your school is going to do, is they're going to issue you an additional I-20 to cover the gap between like graduation and when you start working October 1st, which is the first day of employment for an H-1B. The same is not true for the O-1. So let's say, for example, you have you graduate in May, you have your OPT, it lasts a year, and then your OPT and EAD and grace period, they expire, I'm just making this up, like May 1st, right? And then you have your start date of like August 1st, and you have those like 60 days where you don't have status. There's no cap gap for an O1. You have to either go back home, or you need to work with an attorney who understands when your expiration date is and files you before the last day of your grace period. Technically, you can file up to the last day or the second to last day before your grace period, and that will keep you in O1 pending status. You won't have underlying status, but you'll be in O1 pending status. So H-1B cap exempt. So a couple of years ago, I want to say like 2.5 years ago, the rules concerning the lottery changed. So before you had like a 1 in 3 chance of getting selected if you had a bachelor's degree, but they changed the rules around 2.5 years ago to create a reverse lottery that favored U.S. master's degree holders. To favor U.S. Master's degree holders. So those of you who are applying and have a U.S. master's degree, you are going to be favored within the lottery and thus get accepted and file the petition. So one thing to realize that is different between H-1B and O-1 is H-1B, you have to go kind of like through a couple of steps. The first step is you have to enter into the lottery. This is something that is done online. Your employer or your attorney goes through the USCIS website and enters you into the lottery, obviously with the correct data. If you don't enter the correct data, you will be rejected from the lottery, but enters in the correct data. If you get accepted within the lottery, then you need to prove the merits of the case. So prove that you have specialized knowledge and prove that you will be undergoing a specialty occupation. Specialized knowledge is demonstrated by, number one, a bachelor's degree or a bachelor's degree and a U.S. master's degree. And number two, 4 years of experience for every year of the degree. So roughly the equivalent of 16 years work experience. So this is something that is not often talked about, but you don't necessarily need a bachelor's or a master's degree to be able to qualify or enter into the lottery for the H-1B. If you have the equivalent, which is roughly 4 years for every year of university, around 16 years of work experience, then you can qualify. I hope that answered your question. I heard that Chinese international students who obtain an O-1 cannot go outside the US territory. Is that true? No, that is not true. I think what you're mixing up is the bilateral treaties between the US and certain nations. So certain nations like China, Brazil, Iraq, there are bilateral treaties that govern our entries into the country and our exits in the country. So Chinese nationals, you could stay in the US for 3 years if you wanted to. Most people don't because they have to travel for work and see friends and family, etc. But you can travel out of the US, get your visa stamp, and come back into the US. The issue is the number of entries that you get to come into the US. So nationals from, for example, European countries, they get multiple entries with their O-1s and other visa types. Chinese nationals, Brazilian nationals, Iraqi nationals, they get 1 entry. So what that basically means is every time you have to travel out of the US, you're going to have to undergo visa stamping again. So this means filing the DS-160 again, paying the consular fees again, getting the appointment again. That's probably what you're referring to. What would be a typical time span needed for preparing for an O-1 application? So you're welcome, Len. So this really depends on the attorney. For me, we just filed a successful O-1 in 5 days. I have a major client who's a creative director of a major brand who had to go to Paris. And we did her case in 5 days, approved, no problem. It depends on, I would say, if you're going to someone who is highly focused and knowledge in the arts, focused and knowledge on O-1s, very complex cases, O-1s, EB-1As, EB-2s, or if you're going to like a general immigration attorney. So I would say probably regular attorneys, probably like 6 months to prepare the case. In our law firm, our contracts are for 3 months, but we do them much quicker. But 6 months if you're going to a regular attorney.
Electra, I don't see any more questions, but I think maybe it would be helpful if you talked a little bit about what you do when, say, someone like an artist comes to you and they're thinking about an O, but they don't know if they have the qualifications. How will you work with them to kind of determine if they have that, and then maybe some advice for them as maybe new graduates, some of the things they would need to do if they're not quite ready for like an O?
Great question. I am of the idea that anybody who hustles and who is hungry for it you can definitely develop your qualifications during your OPT period. So I have many people who come to me at the beginning of the OPT timeframe, and they're like, Electra, I want to stay in New York, or I want to stay in the States. What can I do? So at that point, they have already booked something that's called the legal marketing plan, where I kind of outline what they need to do for the next, 8 months, 9 months, 10 months that they have on their OPT. But a couple of rules that I have when I give speeches at universities. Unfortunately, sometimes artists and creators are caught up in the fact of they need to create their art and become proficient artists, entertainers, creatives, and that's fabulous. But you also need to understand the business of the arts, which is critical to your commercial success as an artist, and also for your immigration journey here in the US, especially if you're going to be doing the O1 and EB1A eventually. Now, first rule of thumb, and I always try to connect this to the federal regs. I always try to connect this to the federal regulations so that you can see how we're illustrating it properly. So number one, networking. Networking is critical. You need to get to know the experts in your field. This is directly related to the O1 because one of the requirements is testimonial letters from experts in the field. So for example, if you're a graphic designer and you're in school and you don't really know anyone in the field, meaning you don't know any professional practitioners, then that's a problem, because anything that is typically associated with academia is not considered to be professional work for O1 purposes. So I don't really use professors unless we're really desperate, because the law is very clear, experts within the field. So you need to start networking and getting to know who these experts are who are going to be confirming your creative and professional achievements. Now, the law states you don't need to have worked with them. Of course, if you've worked with them, then that's a plus, but that is not a legal requirement. The legal requirement is that they are experts within the field. Number two, start to establish yourself as a thought leader for your field. What does that mean? And how do we connect this to the O1? If you are somebody who is interested in filmmaking, for example, one way you can establish yourself as a thought leader is by publishing articles. For example, you can publish like how to create a short film in like 5 minutes. Choose the content that you want to create to start to put your name out there. This is important because there is a regulation called national and international recognition that can be satisfied in 2 ways. The first way is publications, meaning you, for national, you're publishing articles, right? How to shoot a short film in 5 minutes, how to create a mise en scène, how to understand depth of field, right? These are articles that you can write about to establish yourself as a thought leader. This is great for your CV and your resume, but also satisfies the requirement for the O1. Another way to satisfy that requirement is press. Now, press is, fortunately for you guys, one of the easier components of the O1 to control. I've worked with many clients who've worked with publicists to be able to get who have structured press for themselves, because press is one of the requirements for the O1. So again, just to recap, my advice would be network. Start to get to know who the players are in your field. Number 2, publish articles. And number 3, get press. Sometimes you're going to have to work with a publicist, but that is something that, if you choose to do, is going to help your O1. And eventually, if you file an EB1 petition, this is going to establish your longevity or your sustained achievement within the field. In the sense, I will have a timeline that I can present to USCIS of your achievements. After winning the H-1B lottery, how soon do you have to submit a petition, and how long does it usually take to file a petition? So the deadline for when you have to file the case and the service center where you need to file the case is going to be included in the approval notice of the lottery. Again, it depends on the profession, and it depends how the person or the attorney wants to argue the case. So for those more I would guess like non-traditional professions, I actually do include letters of recommendation in an H-1B petition. But generally, I don't think that you need, or at least in my firm, I cannot speak for other attorneys. It doesn't take more than a month to prepare. Obviously, ensuring that the petitioner and the beneficiary collaborate with me. One really important thing to know about H-1Bs that it's different from O1s. O1s have a very strong notion of dual representation, where I might be working with the talent, but legally I represent the petitioner or the agent. Whereas H-1B, it is very clear that it is representation on behalf of the petitioner, meaning that if you, the beneficiary, want to get certain documents about your petition, if these documents reveal information that the petitioner does not want you to have, such as financial data, then it is not your right to have them. So important to know, usually H-1Bs are either filed in-house by immigration specialists or outside counsel that you have not chosen, that has been chosen by the company. So your communication might be a little bit more limited as opposed to if you're doing an O1 where you might be working directly with the attorney. I know that one of the requirements for O1 is winning known, able, famous awards using non-schoolwork. Is that correct? Absolutely not. Absolutely not. It is one of the biggest misconceptions about O1s. Do I have clients who have won awards? Absolutely. Is it something that is dispositive to winning the case? Absolutely not. And I will go further and say it's not a numbers game. It's not about quantity versus quality. It's not like you've done 15 projects and I'm going to include all 15 projects. I've done many successful cases where I've just argued one project. So no, you don't need an award. Is it helpful? Absolutely. But other things are helpful too.
I think I'm going to stop us now and have us move on to our three panelists and have them talk briefly about their O1 experience. And then we will open the floor again for questions to Electra or to our panelists. So Electra, that was marvelous. I think that's just right exactly the sort of stuff that we need. So appreciate that. Now I'm going to turn it over to Haylin to talk a little bit about her experience as an O1. Haylin?
Yeah, thank you so much, Electra. Thank you so much for the insight. It's so helpful. I first learned about my attorney through a referral. I applied for my H-1B first as a textile designer in New York City. And then I worked as a textile designer with my H-1B visa for 3 years. And then after I graduated from grad school, I realized that I really want to apply for my O1 visa. And I decided to go with the same attorney that I worked with for my H-1B because she already knew my immigration history and she had the documents to work with. I really enjoyed working with my attorney because she was very direct with all the tasks. And based on that experience, I recommend all of you guys to find an attorney that you can easily connect with or feel comfortable with, because this is someone that you'll be spending at least 6 months to go through a very stressful time. And I would think about choosing your attorney as if you are choosing a teammate for example, like a basketball team. I found the O1 visa process very challenging because I constantly had to prove myself. And there were a lot of times I felt like I'm just not enough. But I want you guys to know that that's just part of the process. That doesn't mean that you're not enough. And I recommend you guys all to find something that you can distract yourself from while working on the artist visa application. For me, doing yoga and writing thank you letters really helped. And for my O1 visa, I want to let you guys know that I used an agent. I asked my previous client to be my agent for my application. And if you guys do decide to go in that route, I recommend you guys to really explain the context of your application, because oftentimes people with US citizenship don't really know how extensive the application process can be. And I remember my previous client being very surprised with all the things that my attorney was asking. So I think it's really helpful for you to prepare them before they get bombarded with all these questions like, how much do you earn? Or how did you pay your tax? Things like that. And my tip for O1 visa is to start early. I remember I was calling my attorney on my last year of grad school. because I wanted to have enough time to prepare for my documents. So I definitely would recommend you to start looking for your attorney if you're thinking of an O1 visa, and start preparing your documents so that you have very strong application for your O1 visa. Thank you. I'll pass it to Eduardo.
Thank you, Helene. So everyone, like, I guess I'm just gonna piggyback on what you were saying, Helene. Like, my situation is a little bit different. I am actually like a full-time teacher here at MICA, and that's how I got the O1 visa. In my case, I wasn't able to actually choose my attorney, which it's I guess a little bit unfortunate. Like on the other side, it's incredibly stressful. Like it's almost like, okay, I didn't choose this person, so I don't know if I'm actually able like to, you know, communicate with them like as much. But in my case, and it's something that is might be like similar maybe with like the accountants that the attorneys that you're going to be working with, right? In my case, there's like 7 categories that you need to, I guess, fulfill. And correct me if I'm wrong, like Electra, please. Like there's kind of like 7 like important kind of
There's 6 for the O1B and 10 for the O1A. So I don't know if you were filed under O1A or
yes,
O1B.
well, both. So, but in this case, right now, like the with the O1, like for this like 6 categories, in my case, what I started doing and is what Helene mentioned, which is like starting. Actually, if I can like name it somehow, is like try to think of yourself as a detective, almost like trying to find as many like if you have like some publications that you've made like, you know, a couple of years back, like just try to do that. As an illustrator myself, one of the things that did work, and I know that I'm trying to see like who was like asking like the big awards, Joy. In my case, I did won like gold medals, like silver medal awards, which were like incredibly helpful for my illustrations. But another thing, and I'm kind of a weird anomaly when it comes to illustration, I do a lot of exhibition work. So I have like back in the day, like back in my hometown before even coming here, I already had like kind of like 20 exhibitions, like and that was like, you know, like something that I also put in my curriculum. One thing, and this is, and Joey, you might be like thinking the opposite, but like in my case, as an illustrator, like I do recommend like for you to apply to competitions, like for as many illustration competitions, American Illustration, American Photography, Society of Illustrators, like, I mean, there's like plenty 3x3, plenty of like competitions that you can apply. And you might be surprised of how many times like your work like gets like chosen. So many times like those like I guess publicized, or it gets in a publication. And that's another thing, like publications, like I was able to bring like, oh, so my illustrations appears in all these catalogs, even if I didn't win like golden awards and everything. Like just the fact that my work was like in these catalogs, I was able to also show that I have like won awards, but I also have like published like stuff. So I have never really published anything, but my work has been in books. So that was like all it needed. Good recommendation among you as friends, like if you start like, let's say an exhibition, you can, you know, create an exhibition among all of you, and that could be added as one of the things that you can put into your portfolio, right? So that was my situation. I guess the lawyer just gave me like this like Excel sheet, like please like just populate this. So as I was saying, like detective-esque like work, try to like collect every single thing that you have done in Instagram that you feel that connects. You can just like start like I guess finding all of those like links, so that can make like easier the job for your attorney. But again, I'm going to stop there just to see like Yohei, another illustrator too, like can have like a different take on this, but that was kind of in my point, the way I navigated this. But yeah, thank you.
Yeah, great. Yeah, Yohei here. Yeah, I think you kind of cover the whole thing. So I'm just kind of like second to what you're all saying. I think the documentation is very important, especially this whole social medias, and like it's just so fast. Everything is just going so fast. And I used to had the folder for just dumping any sort of, you know, awards or letters or anything that I got, like anything that has my name on it. And I document them and highlight them and just, you know, constantly dumping all that document into the folder. I started it when I was an even sophomore, actually, when I was in bachelor, because I knew that I really wanted to stay in the US. But at the same time, well, that's why I also like kept, you know, submitting all the competitions, in illustration competitions. And also I got membership at the Society of Illustrators. You know, it's like a, I don't know, it's like a name. It's, to me, is very important for, it's like my parents, right? It's like, hey, I have got into this competition. It's kind of like, it sounds very huge, and it is a huge thing. So I kind of chased after those names when I was in undergrad. And second to Haileen, like finding attorney is like going on the date. You know, like I went to have I met several attorney back in New York to have just like a 30 minutes consultation. Some attorney charge, but to me, that was kind of like a little investment. And I wanted to feel safe. I wanted my attorney to believe in my work. So unfortunately, right after my bachelor, this attorney was like, you know what? It's okay to go back and build your portfolio. It's fine, blah, blah, blah. So I knew, I was like, oh, maybe I wasn't ready. I don't know. So like, if I met Electra back then, maybe the things are different. But back then, that was kind of, I took it and I was like, you know what? That's the reality, right? And then luckily, I went back to master's. And then when I got off the master's, I felt like I knew I was ready. And then I met to several attorney, and one of them was like, you go ahead, you know, you ready. So I felt like really good about this whole process. So anyway, I did 2 O1s and then changed to J1. And then my case, I won lottery for green card. Yeah, it's just random. So it's just a random thing. So I think, but I was already working on the green card process. So it was just kind of like at the end, I was like, oh, yay. But yeah, but document everything. I think is very, very important. Yeah.
Okay. Thank you, Yohi and Halen and Eduardo. We have.
Can I
Yes.
just pop in? I think that you guys, students, you guys should know that you don't know which criteria get selected. So you need a minimum of 3 criteria to qualify. Probably most attorneys argue 4. I typically argue 4 criteria. So you don't necessarily know which criteria get selected when you get approved for the O1. I think that the common thread from all the O1 holders was the discussion of the portfolio. What is critical and what they all said was the documentation process. What I tell my clients is like, you cannot self-screen. You cannot say this is not relevant, this is not important, because those are analytical discussions and strategic discussions that are held with the attorney. So the best exercise that you can do for yourself, or the best thing you can do for yourself, is just gather as much data as possible, and don't, again, discriminate, because you're not going to see necessarily what the attorney thinks is relevant for the legal arguments. Your job is to be able to present this data so that he or she can craft these legal arguments to ultimately win the case. So the portfolio aspect of the petition is very, very, very important. Just wanted to echo that because they all talked about their portfolio process.
And Electra, there's a question about something that I was like talking about, which is, does online-based publications such as website, online magazines count as publication requirement, or it does have to be a physical book?
So yes, absolutely. So online platforms where work is published about you, absolutely count. Physical books count too. If you self-publish, that's great, but most people have online publications.
And something just to add to that, like Gaon, sorry, I'm not sure if I'm saying your name correctly, Gaon. In my case, like that was definitely one thing that also helped. Like if you have like publications like online that they're talking about your work or things like that, for example, like I don't know, like hyperallergic or things like that, for sure that like counts as like your name being outside. And I'm just like thinking just right out of the bat, like as I was telling you all, like American Illustration, sometimes if you don't get necessarily into the actual book, like you still like get included into something that is called the archive, where your work like shows that you won, or you were maybe not selected for the book, but you were like chosen to like winning, like I guess in a lower, let's say like rank
A
or
special mention.
yeah, a special mention or merit or something, but it's still like you can prove that you won because like the link just like takes you there and your work is among all of the others. So yes, it definitely works.
We have a question about the H-1Bs, basically, and I'll pose this to Electra, basically asking if it's possible to switch employers while you're on an H-1B.
Yes, you can, but you have to file an amended H-1B petition. So you have to file an additional petition with USCIS. Once you receive the receipt notice, you can start working for the new employer.
Okay, very good. All right, there are, we have still a good amount of time. I guess I would want to know if based on these questions from our panelists, are there things that surprised you about your O1, I would say, or an H-1B, but you all were on the O1 process. Any things that you came in expecting and things turned out differently, or you thought it was going to go one way and it went different, or things like that? Yobi, you had your hand up.
Yeah. I had a question to Electra. So, you know, the way I chose my name as work, like artist name, was very strategic. You know, I wanted my name to be like my, you know, Yohei Horishita. But like I know several international students or some people work completely different artist name or pen name. How do you recommend about those? How do you prove that that's actually you as legal name versus the artist name?
It's not something that I have to prove. It's actually asked within the immigration forms. They ask what your legal name is, so the name on your passport, and they ask what the other names are that the beneficiary goes by. Also, us in our testimonial letters, we always write Electra Yao, aka the artist visa lawyer, whatever the person is known as, so that the officer is truly informed about the artist. It's very important to understand the profile of the officer. So they do not, the individual officers do not have your intellectual background, cultural background, artistic background. So they are not artists. And number two, they are not attorneys. They don't have that specialized knowledge that you or I might have about this area of law. So it's very important in every aspect of the petition to be extremely explicit. They are motivated to deny O1 petitions because O1s do not have a cap. It's not like H-1Bs where it's like, okay, we've got 65,000, it's done. No, they are not motivated to approve us because they're not going to want to approve 100,000 people just because 100,000 people qualify. They have changed the regulations or changed the manner of interpretation last year for O1, so that when you're when the officer is analyzing the different regulatory criteria, they're looking at it in the totality. This is directly stolen from EB1A Kazarian analysis, which makes it much more difficult for an individual to apply for the O1 and to get approved for the O1. Not that it's impossible, but again, we don't really have a lot of positivity working with us because we're working with people who don't know art, who don't know the law. Around 7% of officers are attorneys. And we're working with people who have to kind of look at your case the way they would look at a green card case, where the regulations are much more severe and stringent. So yes, I mean, there is definitely a way to explain the artist name versus the legal name.
We have a question. Yes, thank you. Sorry. Says, how do you find an attorney as an undergrad student? So I'll open that up to anybody who wants to answer that, and certainly Electra, your thoughts would be appreciated as well. So anybody? Or
I would
Electra,
say
why don't you go ahead?
the easiest thing is don't go to somebody who is kind of just an immigration attorney. I personally have had to clean up many mistakes of attorneys who have done damage to people just because they didn't understand the nuances of the O1. I have clients where I've had to fix up errors where they chose to go to an attorney because maybe they were of the same cultural or ethnic background, which is totally fine. You can choose anybody you want, but I think that you owe it to yourself to give yourself your best good faith effort at getting an approval, because you've already invested thousands of dollars in university and a master's program and OPT and rent and all that stuff. You really owe it to yourself to go to somebody who understands a little bit about art. It's in my opinion, truly important to have a strategic discussion with your client, with your attorney. If your attorney doesn't really understand who Liza Minnelli is, what a black box theater is, what depth of field is, it's going to be hard for them to argue your achievements within the testimonial letters, which are a vital part of the case. So in my firm, we use the testimonial letters both to satisfy the regulatory criteria of significant recognition, but also as documentary support. This is important because if we go back to what I said about them not understanding art, if I present to them just like a painting, they're not going to understand why you chose water-based colors as opposed to acrylic colors. It's not going to make sense to them, also because it's paper and not on the actual canvas. They're not going to understand the complexity of creating something, which is why the testimonial letters are there to kind of explain your process. So I would say just go to somebody who understands a little bit about art, and finding a lawyer is, I would say most people go through word of mouth, but I'm also like super active on social media. I'm one of the only artist visa lawyers active on social media where I give a lot of information. So I have also a lot of clients from social media. So, but go who you feel comfortable with. And most importantly, go to an attorney that's going to answer your emails, because there's nothing worse than working with somebody. I had a consultation with somebody who's, and they're like, well, do you answer emails? Because when I did my J1, they didn't answer my emails. I'm like, yes, of course. Actually, if you go to a New York licensed attorney, it's an ethical violation for an attorney to not maintain fluid communication with the client. It's an ethical violation. I mean, attorneys do it all the time, but make sure you choose somebody that answers emails.
Okay, the next question is it possible to apply for O1 without commissioned work yet, but having already had several interviews and awards?
The short answer is yes. And the long answer is I would invite you to really look at your career as different sorts of achievements. Commissioned work, so someone seeking out your work and paying you for your work, is a type of achievement. An award is a type of achievement. An interview is a type of recognition. These are all different things that go into your O1 cake, that go into your O1 pie. Is it dispositive? Meaning, like, is it necessary? No, absolutely not. But yes, you can apply without commissions, just like you can apply without shows too. It depends on how the case is argued.
The next question is, this person wants to know how a master's degree can help. How is that an advantage for getting an O1? So
remember, we have to base ourselves on the law. There is no educational requirement for the O1. I've done O1s and EB1As for people who have just graduated from high school. Now, but of course had major careers. No, I would say if you like school, great, go to school. There's a lot of really cool special projects you can do in school, but can you really hustle during your OPT year? Can you really hustle during the summer of undergrad and get those achievements, also international achievements back home, and qualify for the O1? Absolutely. Is it a numbers game? Absolutely not. I'm not looking for 15 shows. I'm looking for quality. So again, if you have money to blow, yeah, of course, go to school. But it is not necessary for the O1 or the EB1A.
So Electra and no, wait, there's another question there, like better.
No, go ahead. We'll get to that. We've got
I was
plenty
just
of
gonna
time.
say, folks, everyone, I guess something important that I want to share. I actually graduated from the MFA in Illustration Practice Program at MICA in 2014. I arrived here with a Fulbright scholarship in 2012 to the United States. So like, because I came here, or I arrived here with a J1 visa, which is an exchange visitor. After 2 years, like I needed to go back to Mexico, where's my hometown. And it was a little bit hard, like breaking, because like they offered me a job at MICA that I couldn't take. So I went back to Mexico, and the regulation says that you need to go back to at least 2 years. I went back for 4 years, but then I made a lot of work there, I guess like a ridiculous amount of work. I just like, I guess as soon as I arrived, I like nonstop like work. So as soon as this like application for like a full-time here at MICA happened, right? I applied, and it was because of the work that I created in those 4 years that I went back that I actually got like, you know, I got the position. So I'm just saying this because not to say, hey, yo, give up, nothing like that. But as is mentioned, like Yohei was like saying also, sometimes if you feel like I might need a little bit more of time, it is possible. Like it is definitely possible, like to just like, I guess, flex a little bit more on your work and coming back if you really, really want it. And of course, I guess like today conversation is more about, yeah, but what if we are here already, right? But I'm just saying, I guess I just want to share this with you because it's not really impossible. Yeah.
Sorry, just to interrupt about the J1, a huge misconceptions by a lot of attorneys is that you have to satisfy the 2-year residency requirement. So for J1s, if you get Fulbright never gives the waiver, they just don't. But in your case, they didn't. The regulations prohibit a change of status. So you can't go from F1 to O1 if you're here on a J1 Fulbright. However, you can do consular processing without satisfying the 2-year residency requirement. So if you're going back home, you're going through the consulate, undergoing visa stamping, you don't need to satisfy the 2-year residency requirement. Many attorneys make this mistake because they think that you can't do, because they think the rule about the change of status also applies to consular processing, and it doesn't for whoever's on a Fulbright.
Thank you.
Electra, have you ever worked with curators on applying O1 successfully? I rarely heard curators on O1 since we don't create art. I'm like the queen of these types of cases. So most attorneys, they file marketing people, architects as O1As in business. I don't believe that. Marketing is creative, it's strategic. Architecture is the same thing, even if you are using scientific and mathematical disciplines to create your plans. Same thing with curators. Same thing with people behind the scenes. You don't need to be the one actually, or not actually, sorry, physically creating. It's the mental creativity and strategy that makes the work creative. I'm going to repeat this again. It is not the physical act of creating. It is the mental thought processes that make the work creative. So yes, I do tons of curators. I do tons of, what is it that we call them? Arts administrators. I do a ton of artist liaisons. This is a term that I made up for people who work between galleries and with artists, for people who sell at auctions. Absolutely. You don't need to be the one physically creating. I've done glamour models. I've done OnlyFans models. I mean, it's not about the traditional like creative and artistic art forms. It's really about like, can I prove that you're using artistry, creativity, and strategy in the work that you're doing? And if the answer is yes, then I can argue that it's artistic. I hope that answers your question.
Electra, where were you when we needed you? So
I used to work in Europe before I opened my firm. So and I worked for other people before I opened up my own firm. But this is, Sandy, this is a great question that you asked, because a lot of people think that you have to physically create art to be an artist. They think that in the real world, and they think that in the O1 world, and that's just not true. And that's why it's very important to work with an attorney that understands the arts, because what happens is you're explaining, you as the client, these artistic concepts to your attorney, and you're like hitting a dead wall. And there's nothing worse than not feeling heard, especially because this has to do with your life, right? Your physical life in the US, your livelihood, so your ability to earn money. And number three, your longevity, like how long are you going to be here in the US? You know, just the thought of like severing your professional relationships and your personal relationships is not a positive thing to think about. So, and to undergo if you get denied. So yeah, think of the processes of being artistic and creative. What would you recommend to STEM full-time designers preparing for an O1? Sometimes you can't apply your work for awards without the employer's permission of the okay, absolutely. Many times clients sign an NDA. And of course, you do not want to violate that NDA because USCIS is not bound by confidentiality for O1 cases. For VAWA cases, which is a humanitarian visa, they are. For O1 cases, they are not bound by confidentiality. And if you're working for a major brand, and we include something in the petition that you're not supposed to, I mean, I wouldn't do it, but let's say, for example, you did, the company has the ability to go after you and to file a civil suit, number one. So in terms of like describing your employer or your projects without directly naming the projects and the employer, there's a way to do that with language. There are many tech companies that work on confidential projects that we're not allowed to name. But if I say something like the largest search engine in the world, the officer is going to understand who I'm talking about or which company I'm talking about. So what you're talking about, So-Yeon, is more about the portfolio again. So think of portfolio as like this expansive display or ensemble of documents proving what you did. So for example, we don't necessarily need the final project of like you, I don't know, behind the scenes at New York Fashion Week. An email. I use emails. I use screenshots of Zoom meetings. I use work notes. I use creative decks. I use a lot of different things to be able to prove that you were a part or collaborated or impacted the project as a whole. So you can absolutely utilize your work without revealing the identity of your employer, and of course, without getting awards. For people, for example, who work in STEM, like, or who are in STEM subjects, like, for example, I don't know, let's say like film. I've had a couple of people in film and STEM subjects. Sometimes you can't really show that you were the one, that you were the gaffer, right? It's just going to be hard to show that you're a gaffer unless the officer really understands like what lighting design is. But I think the most important thing to realize is USCIS is not bound by confidentiality for these case types. So if you're going to choose to explicitly name the employer or the project, you need to get permission. Otherwise, there is descriptive language that can be utilized. And remember, you can always redact information. So sometimes when I want to prove that a client has gotten paid for work and the client has gotten bank transfers, I absolutely use the bank transfers. We obviously redact the personal information because we don't want to pro-offer evidence that we don't need to. USCIS doesn't need to know more than what's required by the law. So you can always redact information as well.
Yeah, it's like I remember when I was working with my attorney, the amount of information that y'all needed, you know, and also the language you use, because like my attorney had creative writer too. So like, you know, I have to give them like how I paint, how I create my work, and all the informations. And then, you know, a couple weeks later, this is like a draft. And I was like, wow, this is so cool. You know, it sounds really like different world. But again, like I think document everything. Yeah, I did a lot of screenshots, you know, I did take photos, you know, if I publish in a magazine, cover, back, and the whole
Exactly.
information, and then stack will be like this, right, at the end, you know. So it's just, yeah, it's amazing that how y'all work, you know, in terms of this O1 case.
Yeah, so you made a really good point about like the amount of data that's included within the O1. So of course, the more famous you are, the smaller the petition is going to be because you're just going to include like the awards and like the famous salient facts. But think of a portfolio, like first portfolio review for us, we're usually at around 100 pages. but our portfolios end up being around 500 pages. Don't be scared about that number. Everyone's like, I don't have 500 pages. You do, you just don't know where to look for it yet because you don't have the proper guidance. But a portfolio, in addition to all the technical data that goes within a petition, we're looking at about 1,500 pages. And the officer has about 10 of these that they are assigned every day. So that's why you've got to be very, very salient in the descriptors and how you're categorizing and qualifying the client, because I know for a fact they don't read past page 5 of the legal brief, which means that if you're submitting a brief that's like 25 pages, and it could be that the person has 25 pages worth of achievements, it's really up to the attorney to really condense that in a way where we're getting the most important facts in the first 5 pages, because they're not reading past page 5.
So I guess
Okay.
consensus, I'm sorry, James, is document, 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 document. And this is no joke, like it's something that it took me like months. Like I was going back like to the very first of my like Facebook like post that I made for this exhibition. I collected and found, incredibly, I found every single one of the flyers or like the postcards of exhibitions. And again, like whatever is going to be the information that you're gonna, I guess, collect, start now and really put the effort into just try to think like the more information I have, the most, I guess, the easiest is going to be for the person to make a case for me.
That's absolutely true. You want to, at this beginning stage, really gather as much data as possible. But I also want to say, don't be surprised when the attorney is developing the case and the legal arguments, and maybe you don't see something that you submitted to her. Maybe you don't see a couple of achievements that were submitted there. These are just strategic decisions that the attorney makes. Sometimes we have clients that just will do data dump and just give me everything. And that doesn't necessarily mean that everything will be included if I don't think that it's relevant or important enough.
Okay, any more questions? Yes, this will be recorded and we will send a link out to everyone that's been on this, and so that you can have access. And I talked with a number of people today who were not able to be here, and they would be very interested in recording. So yes, it is being recorded, as Brandy indicates there. Any advice about if you are choosing not just an attorney, but you're choosing an agent, are they always the same person? Are they distinct? In Halen's case, you talked about one of your early clients wound up being your agent, and I assume that was not the same person as your attorney. Any thoughts about agents? Because again, as Electra has emphasized, if you have an agent, you can have this would facilitate being able to have a variety of opportunities to have commissioned work or work for a variety of employers. So Halen, could you talk a little bit about your situation when you chose your agent, and then other folks want to comment about how they worked with agents while on their O1s?
In my experience, I knew that this was a huge favor to ask for my client. So I chose a client that I worked with for a very long time, and someone who knows of my immigration history. And I think that was really helpful because they were very willing to help me in that way.
Okay, thanks.
I think the agent you're talking about, like a creative agent, Halen?
Well, the person
The agent, the petitioner, the
Oh,
sponsor.
the petition.
Yeah.
Oh, I see. my case, my attorney was also petitioner. Well, not her, but like she had also had like organizations to help like a performers and artists. So that was the case. I was just kind of sorry mixed up with the illustration reps, but I think a lot of times they don't be a sponsor. That's what I heard, but yeah, sorry.
Electra, could you comment about, I mean, do you see situations where is it often case that the attorney is also the agent, or is it usually that the agent is someone else?
So I can't be the attorney of record and the agent at the same time. I cannot have a vested interest in the case and also represent the client. It's a conflict of interest. So by law, an agent is anybody that's a US citizen, anybody that's a green card holder, or any US based company. So let me just clarify that a little bit with a horror story.
Yeah.
So let's say, go ahead.
Yeah. So she wasn't, the
Yeah,
one
her
saying-
company.
Right,
Yeah.
right. Her, yeah. So she recommended
arts organization.
me to the organization. So not like her. Sorry, I have to clarify that.
No. I just wanted to say that because there are some Miami lawyers. And of course, in America, there's different bars based on the state that you're licensed to practice in, even though immigration law is federal. There are some attorneys in Miami that routinely do this. I am a New York licensed attorney. I cannot do this. No attorney in New York can do this, can serve as the agent and also the attorney of record. So a horror story is the agent or petitioner or sponsor controls the petition. I had a client who chose her boyfriend. Her and boyfriend broke up. Boyfriend called USCIS and got the approval revoked, which is by law his right to do. So when you are selecting your agent, it is very important that this person or this entity is aware of their responsibilities. The agent or the employer is undergoing a contract with USCIS. So basically they're saying like, hey, Electra's going to work for the next 3 years, but if she doesn't work, by law, I'm going to be paying for her plane ticket back. That's the law for H-1Bs and for O-1s. Now, let's say I get into a fight with my petitioner and I'm like, I want a copy of my petition. And petitioner's like, no, I'm not giving you a petition scan. By law, they can do that. He or she or it can do that because they control the petition. They're the ones who underwent the contract with the government to sponsor you, to make sure that, hey, if the lecture's not working, I'm making sure that she's going back home, and I'm making sure of that because I'm paying for the plane ticket. And it's important to note that you cannot, that the agent or petitioner or sponsor cannot contract out of that. We can't undergo a private contract where I'm like, I'm not going to pay for her plane ticket back. You cannot, you cannot contract out of that. So it's important that they understand what their responsibilities are. The responsibility is to sign the immigration forms, right? And obviously undergo the contract with USCIS. Sign the agent agreement. So the agent agreement is the conduit which is signaling to USCIS that you're going to be working on behalf of multiple employers. And number 3, receiving courtesy mail on your behalf. Now, USCIS by law has broad investigation powers. If they want to call up your agent and figure out what the relationship is, they can absolutely do that. It doesn't typically happen. It does typically happen that they do call and follow up when there are celebrities attached to the petition. So if somebody's going to be working with, Calatrava, major architect, they're going to call Calatrava. You know what I mean? They're just going to call them and make sure that the contents of the letter and the contract are true and accurate. Another scary story, a client lied to me. I always make sure I have it signed, like there's like a contract and like our intake where, everything that you're telling me is truthful and accurate. So client told me that he was going to be working for a major brand. I drafted the letter of intent or the contract or the summary of the terms of the agreement, which we didn't really talk about, but you need to have work lined up for your O1. This is very important. And because it was a major brand, USCIS called the brand and they're like, we've never heard of this person. This person was instantly sent to the fraud department. When you're sent to the fraud department and when you are flagged, it's almost impossible to get a subsequent approval because you are flagged within the USCIS system due to fraud. So it's very, very important that all of the parties involved in your petition, so the people who are signing the letters of recommendation, the people who are signing the future letters of intent, the agent, they're all fully aware of what their legal responsibility is, because it's not just signing documents or signing a contract. It's not just that. There are legal requirements, for example, to make a letter of intent valid. And I'll talk about that briefly because I think it's very important to know, because a lot of the times there's just bad advice out there. Unfortunately, I did have a client who came to me and was like, oh, my previous attorney structured my job. Can't you find me jobs? And no, we cannot do that. We are not employers. We draft the legal documents, which then explain your future work or your past work, but we cannot broker or structure future work unless you're doing it through like an agency situation where there's clearly, at least the rules in New York state that we can have those sorts of situations, but they need to be very clearly defined for the client, and a different contract needs to be undertaken between the agency and the client. So very rare situations, at least here in New York. So major question that I always get asked about agents: does the agent need to be in your field? No, that is not the legal requirement. If your agent is a mechanic, no problem. They can serve as your agent because the legal requirement is that they are either a US citizen or a green card holder or a US based company. Does it have any bearing on the petition if the entity or the person works in the field? By law, no. This is important to know because a lot of the times clients will get stressed about not having like an agent that works in the field, and it's not the legal requirement. Could you do that? Will it make you feel better? Sure, you can absolutely do that, but it is not a legal requirement. Any other questions about the agent or the agent relationship? I feel like if I ask a US citizen to be my agent with legal requirement or authority, they would feel overwhelmed or pressure to have the responsibility and might be reluctant to be my agent. How should I ask them with less pressure? Well, yes, I mean, they should feel pressure. They're going to be registered by the government. Not everybody is comfortable doing that. Not everybody wants their social security number and their name to be in the USCIS immigration system, because remember, petitions are classified not by your name, so the talent, the beneficiary's name, but by the agent's name. So when you have to like call USCIS and like get information about the case, you're not doing it through your name. Actually, you as a beneficiary cannot call. Only the petitioner or the attorney can call. And you're giving all of the petitioner's data. So the person who you should be asking obviously needs to be aware of this enormous undertaking that they are embarking on your behalf, because like I said, it is legally a contract between the petitioner and USCIS. How should I ask them with less pressure? You have to be honest about what they're going to be doing. Now, part of the honesty is USCIS going to like call them and email them and like try to figure out what you're doing in the next 3 years? No, they hardly do that unless there are suspicions of fraud, but that's a very, very specific type of case. But you just need to be honest. They do need to sign documents. They do need to provide sensitive data, and they will be registered with the government.
Okay, we have technically 15 minutes left, but if we don't have any more questions that come up in the next minute or so, I think what I would ask is first each of our panelists, if they have any last minute tips or advice for students if they're looking to get an H-1B or an O-1. And then I would ask Electra the same thing, and I'm sure she has some marvelous tips for us. So, hey, Lynn, anything that you want to add?
My recommendation would be take advantage of resources at MICA. There are people, alumni or faculty members who had O1 or H1B experience. So maybe you can reach out to those people and ask. You can even ask for the attorney referral or overall experience of the immigration application. So keep that in mind and know that there is always someone who's willing to help you guys if you're having a hard time. Thank you.
Okay, Eduardo?
I would say like definitely just like, again, just to piggyback on that idea. Many of the people that end up helping me is like people like critics that I met at MICA. Like, I mean, when Electra is saying like they need to be professionals in their field, every single teacher that I can think of MICA, they're professionals, like they're artists, like professionals, like in their field. Like some of them are like famous, like worldwide famous. So those are resources just right there, right? And of course, like as Electra is saying, just like asking, being honest. That's all it takes. Like in my case, I was very fortunate that a lot of the people that I met in my program was the people that were like very happy to just help me to get this, I guess, approved. So definitely MICA as a resource, the best. Thank you.
Okay, Yohei?
All of that, networking, and work, honey. Y'all better work.
Okay, we have a last question here. Electra says, I want to ask what would be a good way to get in touch with you on O1 application after this meeting, which I was going to ask Electra to give us a little bit more of her information and a bit more about some of the resources that she has through her firm. So I will turn it over to Electra for the kind of the last word here.
Yeah, before I get into that, I just want to preface that by saying, you guys got this. You shouldn't have imposter syndrome. You guys are here for a reason. And the signal or the sign to yourself is that you are starting to do your research. I always tell my staff and new hires, if you can read, then I can teach you. If you have curiosity, then I can teach you. So the best thing that you're doing for yourself right now is studying. So I'm confident that all of you guys are going to be successful in your petitions, as long as you study who you're going to work with, you document all of your creative and artistic achievements, you network with your colleagues, with your classmates, with your professors, and you put yourself out there. I'm of the firm believer, when you guys are on your OPT, don't say no, say yes. Say yes, do things, free things. Also, the definition of work under your OPT is also pretty broad. You can do free work, you can do your own work. You can also create your own company. Push your mind beyond the limits of whatever is going on in your mind right now. You guys are gonna do fine, you're gonna do great, because you're at this point of gathering information. Now, for me, you can email me. I'm happy to answer like follow-up questions. I'm gonna put my email in the chat. Of course, I can answer like simple questions. For things that are more personalized to you, you'd have to like book a consultation, which is on the website. If you're not ready for that, which you shouldn't be, I recommend just watching my videos online. I've got a lot of information on what makes a good testimonial letter, what is a contract, what makes a contract valid, what is an agent, who should be your agent, why should you select the agent that you selected, should you do a 3-year O1 or a 1-year O1, how can you prep yourself on your O1 for your EB1A. I have a lot of data out there, but definitely email me for my free O1 ebook. And I'm also going to be speaking at the Center for Art Law, which is a huge non-for-profit here in New York for artists and creatives. And I'm going to be centering my discussion on the portfolio. And I've chosen to do that because I've had to clean up a lot of messes of attorneys who think that it is sufficient to just send out printouts of the finalized work. So I think it would be a good and interesting discussion for you guys to get a little bit more detail on the different sort of documents that are going to be included, or that I think should be included within the petition. But I'm on all social media like TikTok, Instagram, and my name is just the law firm name. It's Yao Law Group. And just a little bit about myself. I didn't always want to be a lawyer. I'm from New York originally, and I grew up wanting to be Liza Minnelli. I was very interested in theater, and then I got interested, and I didn't want to go to college. And my parents were like, well, why don't you? And I got into photography, and they're like, enter into this art contest. I'm like, okay, whatever. And I actually ended up winning. It was a national contest. So I went to UT in Austin, and I started to get into documentary filmmaking and had my film screened at various festivals, including South by Southwest. So I've got a very strong understanding of the visual arts and also theater. And I just love art in general. I also have like my own arts-based organization where I try to support artists as much as possible by having art salons. We had our first art exhibition last year. I think it's just really important to constantly talk about art and be involved in art as much as you can, because you don't want to, or at least I don't want to be the type of attorney where I'm just a practitioner. I want to be a participant in the art world, and I think that's important for artists as well. And then I went to law school and I worked abroad. In business law, a different area of law. And I chose to get into O1 and EB1As and EB2s because of my multicultural background and the fact that I wanted to work in an area of law that is very complex. A lot of people don't know this, but there are many different sources of law for immigration. We've got policy memoranda, we've got the federal regulations, we've got the foreign affairs manual, and these are all different laws and regulations and statutes that we need to be aware of when we're crafting a case for USCIS and when we're crafting a case for the Department of State when you're undergoing visa stamping. So I would say, just my parting words is, be confident, don't say no, work as much as you can, ask questions, ask a lot of questions. You want to be that annoying person in the room always asking questions, because you know what, who cares? You're going to get your O1, then you're going to get your green card, and you're going to be a fabulous artist. So always ask questions, and don't be afraid. I know that you guys are artists, so you're already not afraid. You're already very in tune with your emotions. But I'll just restate what I said. I think that you guys are doing a fabulous job by studying first and asking these questions during this session. But please email me. I'll give you guys my free ebook, and I'll give you the link to the Center for Art Law discussion.
Thank you, Electra. I think this has been very helpful. I hope all of our students have found this to be helpful. We will send out a link to the recording of this. I have a variety of resources that I'll send out as well. Our office, we are not attorneys. We don't give legal advice, but we can kind of help point you in the right direction. So if you have some basic questions about H's or O's, as certainly as they relate to your OPT, please get in contact with us, and we can help steer you in the right direction to hopefully wonderful folks like Electra who are doing an amazing job for all of our artists colleagues out there. So thank you everyone for being a part of this workshop and hanging with us throughout the entirety of it. And we will hopefully do this every once in a while because we certainly know that this is an area of great interest for our students, and we want them to have all the opportunities that are available to them for later on. So we want to thank Electra, Helen, Eduardo, and Yohi for their time, and we appreciate all your work that you do for MICA and for the greater artist community out there. So on behalf of Brandy and me, we thank everyone, and hopefully you'll have a good weekend, and we'll do this another time. So look for some information from us in the next few days, and hopefully, as Electra says, you're well on your way to getting your H or your O1. So thank you, everybody. Have a good day, good weekend. Thanks. Bye.
Take care, everyone. Enjoy your
Bye.
weekend.
Thank you.